Hello, and thank you for joining us today for the OSHA, EPLI, and the Biden administration, What Safety and Compliance Changes to Expect in 2021 webinar. My name's Adele Abrams, and I'm the president of the Law Office of Adele L. Abrams, PC, and I'll be your presenter today. Before I could begin, I just wanted to take care of a few housekeeping items. Please make sure that all participants are going to be on mute throughout the presentation. And I'll be reviewing all of the questions received with the assistance of our moderators during the registration process. And if there are additional questions you have through the presentation, please feel free to submit them in the questions section. I will do my best to get to all questions, and if I'm unable to answer your questions during the presentation, I'll contact you directly with an answer. And again, Tandem HR is going to forward any unanswered questions to me to facilitate that. So let's go ahead and get started. What should we be expecting in 2021, the year following 2020, the year from hell? We've had a lot going on, obviously, just in the last couple of weeks. And I was saying before we got started that this is really a snapshot in time. If you listen to this on replay, as we are recording it right now, it's January 28th, 2021. And President Biden has issued scores at this point of executive orders, some of which are dealing with issues in the OSHA, occupational safety and health, and also in the HR arena. And so we are going to talk about some of those. But he's not done yet. He's got plenty of ink left in his pen. And so while I'll be giving you the best information we have as of today, again, we're in a lot of late-breaking development type of situations ripped from the headlines. So, as I mentioned, there's been over 30, I think we've passed 40, we may be close to 50 executive orders issued at this point, even just in the day or so since I prepared these materials. And I will talk about not all of them. Obviously, we can't talk about immigration and a bunch of other things today, but we'll focus on the ones that impact workplace safety and employment law. Another thing that we're going to be talking about is the potential for some of the midnight rules from the Trump administration to be either reopened in the Biden administration or to be rescinded by Congress, presumably with President Biden's consent, under the CRA, and that is the Congressional Review Act. Now, if you're not familiar with that, let me just say it's been used twice on occupational safety and health standards. It has been used on environmental and a few other rules as well, to my knowledge. But the very first use of it was after the Clinton administration, as a transition to the George W. Bush administration. At the very tail end, literally like the last week in office of the Clinton administration, OSHA issued a final rule adopting an ergonomic standard covering musculoskeletal disorders, cumulative trauma disorders, carpal tunnel syndrome, repetitive stress, all of that. And as you might imagine, the business community didn't like that very much. It was a very prescriptive rule. There was a lot in there, for I think everybody to have some disagreement with. And it was rushed to the finish line. So because George W. Bush came in with a red House and Senate, he was able to rescind that. And once the Congressional Review Act is triggered and done by Congress, what it means is that the agency can never go back and redo a rule on that same topic unless the rule is substantively different. So, that happened, in 2021, and OSHA has been hogtied since then from ever doing an ergonomic standard. Also, at the end of the Obama administration, OSHA had rushed to the finish line a continuing violation rule. And that was in response to a court decision as to whether OSHA's 180-day statute of limitations applied to citations involving record-keeping audits, because you have to keep the logs for more years, obviously, than 180 days. And the Court of Appeals, D.C. Circuit, had said, no, that OSHA could only issue citations for violations of their logs that occurred within the previous 180 days. But the court invited OSHA to do a rulemaking to kind of reinstitute its idea that as long as you had to keep a record, it was eligible for citing. So that was the continuing violation rule. Again, rushed to the finish line in January of 2017. And so President Trump and his Red Congress were able to rescind that. And so that obviously ties OSHA's hands in terms of certain enforcement actions. So here we are now, the next change in administration. What midnight rules from the Trump administration may be the target? We will talk about some of these in a bit more detail, but on the employment and labor side, the joint employer rule normally would have fallen into this category, but it was recently rejected by the U.S. District Court. And so that is in an interesting legal limbo that we'll talk about. Also, the independent contractor rule only came out this month in January 2021, and it has not taken effect yet. That one is targeted for rescission either under the Congressional Review Act or it'll be reopened and modified in a substantive way by the Department of Labor. And we'll explain why in a few minutes. There also were a number of Trump-era rulemakings that were left incomplete, and these are ones, if they had been able to get them out the door and through the regulatory clearance process before the inauguration, these rules would look very different than what we're probably going to see. And the biggest ones are the reopening of OSHA's respirable crystalline silica rule, which affects 2 million construction workers and a lot of general industry and maritime workplaces as well. Also, the creation of a similar silica rule for the mining industry, and that has been a big point of contention. There was even an Inspector General report that came out saying that MSHA has been derelict in its duty during the Trump administration for not adopting a silica rule with comparable protections to those that OSHA offers for workers. And then the other big one is workplace violence prevention. This was an initiative that had started under President Obama, and then it was taken off of the front burner. It was put on the side burner, didn't quite fall off the stove. But here's the kicker. The original draft rule was envisioning it just being applicable in the medical community, hospital settings, healthcare, and social services, because those were the sectors where you had the most workplace violence incidents, from patients, from family members, people breaking into a facility to steal drugs, a variety of things. And social services, those are the people who come to your house to take your kids. And as you might imagine, they are met with hostility a lot of times. Workplace violence is the #1 cause of death for women in the workplace. But here's the thing. Since COVID, and we will talk about COVID a bit, workplace violence has really spread out into the retail sector, into the restaurant sector. And so by leaving this initiative uncompleted, this opens the door to the Biden administration broadening the scope of that rule to be applicable across all industry sectors. And there's also, I will say, some work under development looking at the tie-in with the DEI, the Diversity, Equity, and Inclusion initiatives that kind of came out of the BLM movement and the Me Too movement, and that's really impacting in some ways employment procedures and policies already. But now OSHA is recognizing bullying and harassment as being predicate steps to workplace violence, even citable under the general duty clause. So that's just something to sock away, because we won't be talking about workplace violence a lot more here in the presentation. That when we talk about workplace violence, we're not just talking active shooter situations. We're talking about a whole lot more. Another thing is that President Trump had a whole slew of executive orders himself that came in at the start of his administration, and those have all been basically undone. That has been in large measure what President Biden has been wearing out his pen doing. So that whole 1 in, 2 out thing, where any new regulation that was adopted by the Department of Labor, for example, had to be offset by eliminating 2 regulations with a comparable economic impact. That is not going to be in effect anymore. Now, looking at who's going to be calling the shots here, first of all, President Biden has nominated his Secretary of Labor, and that is Boston Mayor Marty Walsh. Now, Marty Walsh used to be with the Boston Building Trades Union. He is a very, very, very strong organized labor activist. And so you can expect that this is going to go back to being the Department of Labor instead of being the Department of Management, which people kind of had a feeling that it was during the Trump administration. So keep that in mind as we go through some of the other things here, both dealing with employment law matters as well as OSHA and MSHA, of course. Now, on the OSHA front, President Biden has also named Jim Frederick, who is a retired official with the United Steelworkers of America, a safety official, but of late had been working for ORC, which is formerly, I think it was known as Organization Resource Counselors, which is in turn part of the National Safety Council. So he has pretty good pedigree. If they choose to keep him in that job permanently, there will obviously be some opposition on the red side of the aisle to having any union person heading OSHA, but he certainly is well qualified for the position. And then on the Mine Safety and Health Administration side, so far no names have bubbled up. Patricia Sylvie, who had been a career deputy at MSHA. She is the acting Assistant Secretary of Labor for MSHA right now. And I might add that Pat Sylvie is the, I think, longest serving employee of MSHA. She was there at the very start of the agency. She's an attorney. She was their director of standards for many years until finally becoming their deputy. So, if they take a while to find somebody for the MSHA position, she is certainly well qualified for that role. So that is who's going to be guiding the ship of state, or at least adjusting the sails, if you would, in terms of the direction that OSHA, MSHA, the other agencies within the Department of Labor that do employment policy, where they're going to be headed. So moving on from that, one thing I did want to mention is that the cost of violating OSHA and MSHA rules has gone up as of January 15th, 2021. So this is part of the whole rip from the headline stuff. And the new OSHA maximum penalty for willful and repeat violations is $136,532 with a minimum penalty of $9,753. So that is not small potatoes. And when you have those kind of minimums, typically both the agency and the judges are constrained from going below those in settlement. Now, clearly they could reclassify a citation and get to a lower penalty amount that way. But for your other serious and your other than serious violations, the maximum is $13,653. And that's also the penalty per day, though, for failure to abate a violation. And they're not playing with that. Make sure that you get your paperwork in on time. Now, on the MSHA front, and I won't be talking much about MSHA, but be aware, if you're a contractor doing construction, perhaps you're putting a new roof on a scale house at a quarry, you are now under MSHA jurisdiction, and cement plants, alumina facilities, iron pellet processing, Those are things that are under MSHA that people sometimes aren't aware of. So MSHA, they don't mess around. Their maximum penalty just went up to $274,175 per violation. And MSHA has strict liability. They have mandatory inspections and warrantless searches. So if you are a contractor who does any work on mine sites, really mind your P's and Q's. Things were kind of lax, in my view, during the Trump administration. And I think a new sheriff's in town, as they say. MSHA also has some mandatory minimum penalties for late reporting of accidents. It's a 15-minute reporting for fatalities and any injuries with a reasonable potential to result in death. So that's now $6,232 if you blow that 15-minute deadline. They have $8,100 a day for failure to abate. And then there are unwarrantable failure violations, which are the equivalent to an OSHA willful. Those have gone up for mandatory minimums, and these again are statutory amounts, so they cannot be deviated from in settlement or at trial. Nearly $2,500 for a 104D1 unwarrantable failure violation, and nearly $5,000, $4,983 for Section 104D2 orders, which also serve to withdraw your crew from the area or the piece of equipment involved. So that's what things are looking at as we are on the cusp of going in now here to a whole new enforcement philosophy at OSHA and at MSHA, where they're not going to be giving the employers some of the breaks that they were cutting before. So again, if you let your program slide, now is the time to really reboot it and get serious about safety. So what is on the wish list for these unions that certainly have the ear of Boston Mayor Walsh, who's going to be the head of the Department of Labor in all likelihood? First of all, enforcement. They say enforcement is critical, especially on the COVID front, and adoption of an emergency temporary standard by federal OSHA and MSHA is vital. Well, as we've already heard, unless you've been pulling the covers up over your head and not listening, President Biden, through executive order, has already committed to fast-tracking some COVID revised policies and also requiring OSHA and MSHA to take a look at things. So we'll talk about that in a few minutes. It was passed without a lot of notice, not unlike my 25th anniversary from law school last year. But December 2020 was the 50th anniversary of the OSHA Act. And the Trump administration didn't have any kind of real celebrations or anything. But the unions are saying this is a good point to stop, assess, rebuild, and restart effective programs. So you can expect a lot of that navel gazing. I would expect that we will see some shareholder or stakeholder meetings, that will be public facing. The Trump administration did a lot of stakeholder meetings, but a lot of them were private facing, where selected associations were invited up to the Department of Labor to speak about which rules to kill. But the unions were not really invited up there and did not enjoy the same open door policy. So that's definitely something that's going to change. Regulatory priorities will also be stressed by the unions. And a lot of these, as you can see on the slide, fall into the occupational health area, not so much the safety area. So infectious disease prevention, which had been on the agenda even before COVID, and a rule had been nearing the point where it could have been put out for comment, but then it was again taken off the stove by the Trump administration. So that'll be back on, but probably initially through the prism of the COVID emergency standards. Heat exposure, heat stress is a big issue for certain industries. And I have definitely handled cases where people have been hospitalized, where deaths have been suspected to be heat related. And OSHA, in the last year, lost a couple of big cases using the general duty clause to enforce protections from heat stress. And in one of them, in fact, the judge even said that OSHA could no longer rely on the National Weather Service's heat index for enforcement purposes, because it had not been scientifically, vetted for that purpose. So I think there's a recognition now in the new administration that in order to be able to protect workers from heat stress at all, they're going to have to do a standalone rule. And so expect that to be added to the agenda. And then, as I mentioned, the workplace violence rules are also a union priority, especially among healthcare workers, teachers unions too. Obviously in the wake of Sandy Hook and Parkland, protection of teachers from workplace violence has been a pivotal issue. Now, beyond that, chemical exposure updates is also on their wish list. And this is a complicated issue, I have to say. I remember, because I've been doing this a while, but back in 1989, when I was still a safety and health professional before I was an attorney, OSHA did a group rulemaking about 428 substances, I believe, all at once to update the permissible exposure limits. And the court shot it down. OSHA actually was sued by the unions, who said that the numbers that they picked were pulled out of the air and they weren't sufficiently protective and they had not explained their rationale sufficiently. And the business community sued as well, saying the number that they picked out of the air is too stringent, and they did not build a record showing why that number was effective and a higher number wouldn't be effective. And the court said, right, what? You're both right. OSHA screwed it up. So they threw the rule out. And since then, we have not really had updates of these chemical exposure limits, except in isolated situations like the beryllium rule, the silica rule, et cetera. And so this is on the agenda. I see maybe a approach at doing a negotiated rulemaking for this. There were some baby steps towards that, probably back in the Obama administration's early years, as well as in the Clinton administration. So maybe the third time will be the charm. But just remember, OSHA's exposure limits, for the most part, were set based upon 1960s exposure limits from the ACGIH, the American Conference of Governmental Industrial Hygienists. NIOSH has recommended exposure limits that in many cases are more protective than OSHA. So for best practices, protect your workers to at least, standards that were identified in the last 20 years and not ones that are 50 years old. And similarly, ACGIH updates its threshold limit values on an annual basis. And those are going to be your most protective standards until such time as OSHA gets around to addressing this. And the same thing goes for MSHA too, by the way. Invigoration of OSHA advisory committees. These were never really abolished. OSHA has the ACOSH, which is the Advisory Committee on Construction Safety and Health. They have NACOSH, which is the National Advisory Committee on Occupational Safety and Health, and MACOSH. And as you might guess, one is construction-oriented, one is general industry-oriented, and one is maritime-oriented. And NIOSH is typically a partner with OSHA on these, as well as representatives from the labor and the management communities and the safety health community, and from representatives of the state plans. So these have been out there, but through attrition, they had lost some membership, and then they just weren't meeting very often. So again, expect this to be rebooted. Beyond that, there's been kind of in the past 4 years, and COVID, we'll talk about in a moment, is a very good example of this, where hazards are recognized or solutions are recognized, and OSHA is just so log jammed in terms of the protocols they have to roll through that the state plan states, the 22 states that run their own OSHA programs, plus there are territories that do it as well, they're more nimble. And they have, standard-setting boards that can pump out a rule, relatively quickly. So that has been happening. And the unions say, look, we have to harmonize this, but, bring OSHA into this century. There's also issues, frankly, from a legal perspective, as far as disparate protections across geographical lines. And COVID, again, great example of that, where Virginia has an emergency standard, but Pennsylvania and Maryland don't. So if you're a construction company and you have crews that go out to the 3 states, you're going to have different programs and different protections for workers depending on where they're located. And if you use third parties like people from a staffing agency and afford these, again, disparate protections, that is going to be a problem. We also have that in the OSHA versus MSHA arena right now, specifically having to do with silica exposure, where OSHA's limit is 50 micrograms per cubic meter. MSHA's is 100, and I'm already seeing workers' comp cases bubbling up on the MSHA side saying, look, your own sampling data show that, even though we're below 100, we're above 50, and 50 is the number that OSHA said and the court agreed is consistent with the development of cancer and silicosis and a whole host of other diseases. So be attuned to those things. Be proactive. Eventually, if they have sufficient time and energy, the Biden administration, I think, is going to do its best to level that playing field. And that is something that I've been hearing, is they're really looking at this equity issue and different strokes for different folks. But in the meantime, there's nothing preventing you from going beyond minimum compliance. So let's take a look beyond what I've already said about the occupational health and safety outlook for the new administration. COVID, it's not just the elephant in the corner, it's the lion at the front door that's roaring. There's going to have to be an emergency standard, but it will not be forced by legislation the way the House of Representatives was trying to do in the Trump administration, because the executive branch is already saying, yeah, cool, we're gonna go forward with this. So that'll save congressional energy for dealing with other issues. And we'll talk about some of those in a few minutes. As I mentioned, there are 4 state OSHA agencies that have now adopted formally binding COVID emergency temporary standards that are enforceable through their state OSHA agencies. And those are Virginia, Michigan, Oregon, and California. There are at least 10 other states, though, that in most part are federal OSHA jurisdictions that have said, look, federal, and this is again under Trump, federal OSHA isn't doing anything sufficient here to protect workers, and so we're going to regulate this. And they kind of took that authority away from OSHA. They adopted workplace safety and health rules specific to COVID, and they're enforcing them through their state health departments. New Jersey is a good example of that. But again, once we have a federal OSHA standard, there won't be that need to have that crazy quilt where at this point there's at least 14 separate requirements that I'm aware of. A multi-state company is going to have to address that. Another thing that we are definitely going to be seeing a push for over the next year to 2 years is going to be increased criminal penalties and increased use of the existing criminal penalties by coordination between the U.S. Department of Justice, the Department of Labor, and the EPA. And in 2015, President Obama had, I guess, encouraged, and there was an interagency memorandum of agreement, or memorandum of understanding, excuse me, between the Department of Labor and the Department of Justice. And they put about 93 U.S. attorneys who were in the environmental crimes unit through training on how to look at environmental laws and apply them to OSHA and MSHA types of violations so they could be a felony rather than a misdemeanor. Same thing with looking at 18 U.S. code to see if they could use those for obstruction of justice, conspiracy, witness tampering. Because again, those are under the federal sentencing guidelines. You can get 20 years for that. Whereas if you willfully kill a worker currently under the OSHA Act and it's directly related to a violation, the maximum is 6 months in the federal pen and I think a $50,000 fine. So clearly those are out of step. And there is legislation. I have this mentioned on a slide a bit later, the Protecting America's Workers Act. But one of the hallmarks of that in previous Congresses, it's never passed, but we're at the triple witching hour now with a blue executive branch and House and Senate. That would increase criminal penalties for OSHA violations from 6 months to 10 years, and it would change it from a willful violation to a knowing violation, which is a lower bar. And it would also expand criminal prosecution to cases involving injuries short of a fatality, but where there's a serious bodily injury, including things like disfigurement and even traumatic brain injuries. So I could see that being peeled off from omnibus, massive OSHA reform legislation, and maybe trying to do a quick run just on targeting the criminal penalties portion. So stay attuned on that. Also, OSHA is going to probably return to greater use of their egregious penalty provisions, which allow them to issue a separate citation and a separate penalty for each exposed worker. So let's say you have a conveyor line and it wasn't locked out. And there are 10 workers on it, all exposed to a hazard of being caught in the conveyor. The maximum penalty for a willful, $136,000 times 10. So now you're just shy of $1.5 million. So they weren't doing much of that during the Trump administration, but I do see a return to that. Also, strengthening of whistleblower protections under the OSHA Act and the Mine Act. Currently, Section 11C of the OSHA Act only has a 30-day statute of limitations, although the electronic record-keeping rule did provide OSHA with the ability to issue citations under 29 CFR 1904.36 for retaliation against a worker who reports an injury or an illness, or engages in any protected activity under Section 11C. So if the worker blows the 30 days under 11C to file a complaint with OSHA, they now have 180 days to notify OSHA. Then OSHA can issue a citation, fine the employer up to $136,000, and require the worker to be reinstated. This is just an example, as abatement. So that did happen, and that was done in 2016 through the Obama electronic record-keeping rule. But again, that isn't a power that OSHA used under President Trump. I think they will be using it more. There's also going to be increased use of injury and illness data for enforcement. OSHA 2 years ago just won a major court victory that reaffirmed its 30-year multi-employer citation policy. And so now we no longer have a split in the circuits. They were trying to force the case actually to go up to the Supreme Court, hoping that the Fifth Circuit would invalidate it, creating that split, but it didn't happen. So that multi-employer policy where OSHA has discretion to cite the controlling employer, who is typically the general contractor or the host employer, the creating employer, who is the entity who creates the hazard or violation. The next is the exposing employer, and that's the employer whose workers are exposed to the violative condition, even if they didn't create it. And the last category is the correcting employer, and that is the entity who, by contract or in practice, is responsible for abatement. And of course, the company can wear more than one of those hats, but that policy is here to stay. So especially for those of you on the construction side, make sure that you are aware of that. Another thing, and this is a big one, is that there will be renewed scrutiny of safety incentive programs that rely on lagging indicators. That's where you give somebody a gift card because they've gone a year without a lost time accident, or you host a steak dinner for the crew for having attained some injury benchmark like that. This had been the rule under President Obama, that those kind of programs violated workers' rights under Section 11C because it deprived them of some kind of tangible benefit because they had been injured, and that in turn, interfered with their right to report injuries. The Trump administration backslid on that and said those kind of programs were okay as long as they were operated within a legitimate safety program. And drug testing as well is in the forefront here now because, again, under President Obama, through the electronic record-keeping rule, they said that testing an injured worker solely because they were injured was violative of that worker's rights. The Trump administration changed that up with policy in 2018 and said you could test workers even without suspecting impairment. as long as it was part of a root cause investigation. But all indications are that they are going to flip back to the original 2016 Obama interpretation that can be found in the preamble to that electronic record keeping rule from back then. So those are some of the big things that I see coming in terms of OSHA enforcement. There's going to likely be rescission of some of the Department of Labor policies that weakened enforcement for COVID. And of course, again, if you turn on the news, you'll hear that because President Biden put that in his executive order, gave them 2 weeks, in fact, to put out some new policies. I expect we will see some new additional national emphasis programs launched, but it's hard to predict which ones they may be. And then on the MSHA side, there'll be some new initiatives as well, including their emphasis on powered haulage, contractor safety, and also electrical safety. Those are kind of the big three for MSHA. Now, what was on the fall regulatory agenda? I have this up here. I'm not going to spend much time on it, though, because this was written by the Trump administration with the expectation that the Trump administration was going to have 4 more years, and they didn't. So there's nothing on here that's really binding on the Biden administration. And when they do their spring 2021 agenda, I expect it to look quite different. But OSHA did have at the pre-rule stage the workplace violence rule, also a modification of the blood lead level that triggers medical removal. There was also going to be potentially the start of a reboot of the hazard communication standard. And yeah, I know I can hear you right through the screen here. I'm aware that they just rebooted that in 2012. But the problem is the rulemaking took so long that by the time that was finalized, we were several iterations behind the rest of the industrialized world in terms of adopting the global harmonization system concepts. So there's going to be some further alignment of that, and OSHA continues to be part of that national UN group that has been looking at the GHS programs. Now, at the proposed rule stage, there had been a notice of proposed rulemaking to make some changes to the powered industrial truck standards, forklifts basically, that should have come out last month, but it didn't. And so that is one of these rules that if it stays on the agenda, it'll be crafted under a labor-friendly administration. Lockout tagout. A notice of proposed rulemaking is due on that in April of 2021. And that is, again, that was on the Trump agenda, but looking at some of the computer advances in lockout systems that really OSHA has been having to address on a case-by-case basis through variances. So that's what's going on with that. And that may stay on the agenda to come out in April of this year. There's also a tree care standard that had been going through the small business clearance process, and keep an eye on that one. You may not be a backyard, landscaping company, but the scope of this standard is actually a lot broader. It covers, for example, clearing an area to prepare it for construction. Golf courses are covered by this, so there's a lot of oddball things out there. Revision to the crystalline silica rule on the OSHA side. The Trump administration had started reopening this with an idea toward expanding Table 1 for construction to add additional tasks, types of equipment, that if you follow Table 1, it eliminates the need to do the periodic exposure monitoring. Also looking at adding Table 1 to the general industry rule. The other thing is that OSHA was ordered by the court in 2017 to reopen the silica rule and explain why and reconsider whether they should include a medical removal provision. This is a thorny topic. It is not like the lead medical removal because with silica, there's no biomarker. Your lungs don't go back to normal if you predicate it on an X-ray. And for most of these industries, there's no non-silica exposing positions to which someone could be transferred. So if medical removal ends up being included in the silica rule, now that it's being reopened under the Biden administration, that's going to put a lot of workers, I think, on permanent partial disability for workers' comp purposes. The fall agenda from the Trump administration had looked at their 2018 policy on incentive programs and drug testing and had sought to codify that so it couldn't be flipped back by the Biden administration. But they did not get that one to the finish line. So the Biden administration will be free to return to that more stringent restriction on drug testing workers and on the types of incentive programs. There's also changes to the mechanical power press rule, some minor modifications on the walking working surfaces rule, and then they were looking at rebooting the procedures for handling whistleblower complaints. And once again, that had been due in January 2021, where we are now. It did not happen. I think that will occur. But again, the rebooted procedures for whistleblower complaints are going to be a lot more protective of workers' rights drafted under the Biden administration than they probably would have been in the draft that was underway in the Trump administration. In fact, the Trump administration abolished the whistleblower advisory committee that had been set up under President Obama. So that's the OSHA agenda. On the MSHA agenda, again, not much that applies to most of you. They are looking, though, and I want to flag this one, at changing the diesel particulate rules for underground coal miners, and also looking at metal, non-metal. Now, OSHA does not have a diesel particulate standard. MSHA adopted one quite a while ago now for the metal and non-metal underground mining sectors, and they use total carbon as a surrogate, and it's 160 micrograms per cubic meter, I believe, for an 8-hour average. Those kind of exposures above that are found in some construction equipment, tunneling operations, maintenance shops, bus terminals, things like that. And so be aware that if they proceed with this on the MSHA side, again, looking at that parity, we could have a diesel particulate rule pop up on the OSHA agenda. And then, as mentioned, MSHA is going to revise its silica rule, in part because they have to bring some consistency, but also because of that Inspector General report. They're also going to be looking at potentially, or it had been suggested, doing a reboot of their Part 50 reporting requirements, including that 15-minute rule. But that was supposed to have been done by May 2021. It's on the Trump agenda. I don't see that being changed under President Biden. So let's look at a few other interesting things here. In July of 2020, the Trump administration's OSHA issued a final rule on medical records, and the rule ostensibly was to protect worker privacy on their medical records and also streamline review of medical records during inspections. The timing of this was very suspect because essentially what this does now is, instead of an inspector being able to do a record audit and then verify what's on the logs by looking at your workers' comp records or personnel files, before they can get into those records, they have to go to headquarters. This is an inspector in Wisconsin or Texas or Atlanta having to file a request with a newly created position of medical records officer at OSHA headquarters in DC in order to get permission to get into those files. And so it really hamstrings the ability of OSHA to also see what kind of COVID cases maybe are being paid for by workers' comp, but were not included on the OSHA logs. I think this is one that could be rescinded under the Congressional Review Act. OSHA also is prohibited by this rule from releasing any worker medical information except pertinent to NIOSH research or in enforcement cases where worker health is a concern. So again, this is a major limitation. It was kind of a stealthy rule. OSHA, under Trump, rebooted its site-specific targeting inspection program. This, I think, will continue with some changes. This is for non-construction workplaces with 20 or more workers. And what they're doing is using the OSHA electronic record-keeping data and putting employers who are in these high hazard sectors who also have higher than average DART rates over a period of 3 years on the list to be inspected. They made a change to this, again, can't make this stuff up, December 16th, 2020, now saying instead of looking at just 1 year, you are going to look at these 3 years, and that an inspector has discretion. If they don't see that the rate's been going up, they can turn it into a record audit only inspection rather than a wall-to-wall inspection. So it gave a lot more discretion to the inspectors. Again, this could be beefed up, though, by the incoming OSHA. Another thing likely to change, last minute stuff, the Department of Labor in September 2020 put out a policy that covers all of its agencies, OSHA, MSHA, the employment law sectors, that they cannot put out press releases anymore that identify employers in enforcement actions until the case is finally adjudicated. And so this, again, was put out in part I think because some employers are screaming about the press releases on their COVID citations and fines. And so this certainly would delay by 2 to 3 years in some cases, or even longer, any public notice about who's getting cited for what in these egregious cases, in these cases under what had been the severe violator enforcement program. So look for that to be rescinded pretty quickly. And, you know, ironically, this was done right after an American Economic Review study in June of 2020 came out and said, these kind of press releases, this behavioral economics, public shaming, you might call it, but OSHA was calling it behavioral economics, that is more effective on a regional basis in reducing violations at similarly situated operations than actual having an inspection. So, you know, take that for what it's worth, but I think those will be coming back. Now, what about COVID? Real quickly, you know, I don't want to turn this into a COVID webinar because we do have other things to cover here still. But President Biden signed that executive order as his first order of business, pretty much, directing the regulators to issue stronger guidance by February 5th, 2021. So that's a date to mark on your calendar that's coming up next week. And OSHA has to consider whether an emergency temporary standard is needed, which would typically include the requirement for masks, social distancing, hand washing breaks, training, and communication with workers about positive cases, because those are the elements that are pretty much in these 4 state plan ETSs. But they have to make a decision on that by March 15th. So tick-tock, beware the Ides of March. MSHA, Mine Safety and Health Administration, there's nothing specifically enumerated in terms of a timetable for them under that executive order, however. But one of the things that is also in this this massive executive orders is that the Department of Labor needs to look at whether the OSHA emergency standard should be extended to workplaces typically outside of OSHA jurisdiction. And that means they could take an OSHA rule, enforce it at MSHA sites under the Interagency Memorandum of Agreement, maybe at nuclear sites, airline, aviation industry. There's some carve-outs there. There's some railroad stuff. And that even could bring them into public sector workplaces in federal OSHA states that do not have public sector worker coverage. Currently, New Jersey, New York, Illinois, and Connecticut are the only 4 state federal OSHA states that cover public sector workers. All of the state plan states must, however. So that is a gap, though, that's been identified. And so OSHA has to also look at their enforcement actions relative to COVID and ensure equity in enforcement. In other words, make sure that, you know, your people of color in the workplace are being protected equivalent to the white-collar workers who maybe can work remotely. OSHA has been directed to launch a new national emphasis program focusing on the COVID violations that put the largest number of workers at risk, and also to launch a multilingual outreach campaign because, especially in the protein industry, many of the workers who are dying or having severe COVID cases are minority workers. You know, something like 65% of COVID deaths have been among minorities and people of color, which is definitely out of sync with their representation in the population. And just as an example, under the Trump administration, there was a protein plant employee who got fined $15,000 for COVID violations, but 6 workers died and 290 of them were positive. And this may have been the plant where the supervisors were betting on how many workers were going to die and how many workers were going to be hospitalized, in any given week. So, I do not think we're going to be seeing this kind of slap on the wrist under the Biden OSHA. I think we're going to be seeing people go into prison. So what else do we have? On the reporting, again, this is going to be changing. In a last minute move at the end of September, the Trump OSHA said that employers should no longer report any hospitalization cases to OSHA for COVID under their severe injury reporting rule. You would still need to notify them if a worker died within 30 days of contracting COVID. But they said, well, the exposure isn't when a worker becomes symptomatic. It's when the virus flies up their nose, and no workers become ill enough within 24 hours to have to be hospitalized. And therefore, that 24-hour having the hospitalization occur within 24 hours of the triggering event, that is inapplicable to COVID. So not only do I think that President Biden will change that, but currently that conflicts with the state COVID OSHA rules. So please watch out for that. Do not take that to the bank. But you do have to record COVID cases. So reportability is different from recording. You have to record the COVID cases if there is objective evidence that a case may be work-related and the evidence is reasonably available to the employer. So that means you have to do your due diligence, consider their exposure to workers known to be positive, how long was that exposure, how close was it, were there controls in place like barriers or enhanced ventilation, what PPE was worn, etc. And, if it appears more likely than not that it was contagion in the workplace, you do need to put that on your log. Now, OSHA in November, again, this is lagging indicator stuff here, but they issued guidance on what they were citing for the most part. And really, it was respiratory protection. It was failing to keep records. It was inappropriate storage of respirators. It was not conducting the hazard assessment for PPE, inadequate training, not having written programs with site-specific procedures, and not doing medical evaluations before workers are fit tested. There is some latitude for COVID, but if a worker has never worn a respirator before, they do have to be medically evaluated and fit tested before you can put one in for the first time. The annual fit test, OSHA's given some laxity on that, but if you haven't worn one before, you have to go through those tests. Beyond that, for MSHA, they have been really asleep at the wheel, in my view, on this, which is sad. I do a lot of work in the mining sector, and there have been a lot of outbreaks because of the conditions of work. But MSHA does have a COVID plan that really is pretty much OSHA and CDC info. You do have to notify MSHA if you're closing your facility due to COVID, even if you're closing it just for a couple of days. And they've started asking mine operators and contractors at mines to give them information about the number of COVID cases. So they have started doing some surveillance. As I mentioned, there are the 4 states that have their own state plan COVID rules. Additionally, there's the states that have adopted these enforceable through the health departments. And then in terms of legislation, we've been pretty busy focusing on COVID in Congress, focusing on confirmations and focusing on impeachment. So the bills really haven't been introduced yet for the 117th Congress, which is the one that convened this month. But you can take a look at some of the Democratic wish list legislation left over from the 116th Congress. That omnibus OSHA reform bill, the Protecting America's Workers Act, that has the expanded whistleblower rights, the enhanced criminal penalties, public sector worker coverage, immediate abatement requirements, interest being charged on violations that you have under contest. There's a lot to it. The last version of that was over 70 pages. Workplace violence prevention legislation, heat stress legislation, even COVID legislation. There'll be no need for that because I think the Biden OSHA is going to be receptive to doing those rules. We might see bipartisan legislation to codify the voluntary protection program. That was kicking around last year, but it never got anywhere. And then there could be mine safety legislation. The Byrd Mine Safety Act from the 115th Congress could be reintroduced, as well as a separately launched public sector coverage bill. So those are a few of the things legislatively. Now, very quickly on the labor side, back a year ago, just almost exactly, last February 2nd, 2020, the House voted to pass the Protecting the Right to Organize Act, and that was a omnibus package of pro-union proposals to make organizing easier. Well, that has not yet been reintroduced, but that is actually the Biden labor agenda to eliminate state right to work laws that prohibit workers from being forced to join a union or financially support one. Require employers to give all worker contact information to the unions, even if a worker objects, reclassifying workers for gig economy companies to make them eligible to be organized. And that one especially is at the heart of overturning the January 2021 Department of Labor independent contractor rule, as well as an NLRB decision, and I have those very quickly in slides coming up here. Also, Biden's American Rescue Plan is making federal contractors lead by example. It raises the federal minimum wage to $15 an hour. It requires federal contractors to provide emergency paid leave. And they've also issued an executive order asking the Department of Labor to clarify that workers have a federally guaranteed right to refuse employment that will jeopardize their health, and that they will qualify for unemployment insurance benefits if they do so. So that's a big deal. I will say there's already case law with OSHA and MSHA establishing a worker right to refuse unsafe and unhealthful work under Section 11C of the OSHA Act and Section 105C of the Mine Act. But this is kind of a big deal. And then you can also expect that there's going to be major emphasis on the diversity, equity, and inclusion for federal contractors. And this is flipping the ban that the Trump administration issued last year, prohibiting federal contractors from doing diversity training. So instead of it being illegal to do the training now, I think it's going to be mandated, with the idea that that will help shift the needle for smaller businesses, that these contractors can lead by example. On the NLRB side, been a big shakeup there. Biden fired the chief labor counsel and the deputy labor counsel for the NLRB. And obviously, they're going to be replaced with Democrats. In addition, the Democratic board chair, Lauren McFerrin, she's now been made the chairman of the NLRB. She had been a board member, but there had been a Republican chair. So they swapped places. There's also a vacancy on the board, and there's another board position that will expire in August of this year. So President Biden will get to fill both of those, which will then restore a Democratic majority to the NLRB. And at that point, that's when the action's going to start. That's when that Boeing policy that made it difficult for employees and unions to contend that an employee handbook or other policies interfered with protected rights, that'll probably get flipped. The Super Shuttle case, which made it easier to call Lyft and Uber and Super Shuttle and other people, independent contractors, by emphasizing the workers' entrepreneurial opportunities like getting tips and setting a schedule. I think that'll probably get flipped. The social media policy that allows employers to ban certain postings That'll probably be flipped, to make it easier for workers to freely speak about the company and supervisors who've interfered with their rights, and to use social media platforms for organizing. The joint employer rule came out last year, and this was something that the business community was really pushing for. It has to do primarily with franchise operations and when they would be considered a unitary employer. But it also trickles down to impact things like staffing agency agreements. This already took effect in March of 2020. It may be able to squeak through on the Congressional Review Act, but more likely the rule could be reopened. And this actually was kind of codifying NLRB policy over on the Department of Labor side, because there had been the Browning-Ferris decision that had been reversed by the Republican NLRB. So this was now reversing the old Obama joint employer policy, which conformed with Browning-Ferris, to bring it in line with the NLRB policy. I know this, you probably need a Venn diagram for all of this, but the bottom line is that the current joint employer rule, the 2021, allows employers to exercise more indirect control without being considered a joint employer. And the bottom line is there were 17 states and the District of Columbia that filed suit against this. And just in September, the U.S. District Court deemed this rule to be arbitrary and capricious and threw it out. Now, had the Trump administration had a second term, they'd be fighting tooth and nail through, probably all the way up to SCOTUS on this. The Biden administration is not likely to try to preserve this rule, so it's going to die the death of a dog. But here is the test, and again, it's not in effect anymore, but just for your reference. And then the independent contractor rule that I mentioned up front came out on January 8th. 2021. It has not taken effect yet. It would take effect on March 8th, but it is likely to be rescinded under the Congressional Review Act. And this, again, kind of a gift to the business community by making it easier to classify workers as independent contractors rather than as W-2 employees who you'd have to pay benefits to and FICA wages. And it emphasizes the nature and degree of control over work and the worker's opportunity to make a profit or loss. Again, similar to the entrepreneurial opportunity in that super shuttle case. So those are really the main things there. And then very quickly here, because we are at the top of the hour, just be aware that the other shoe to drop is medical cannabis. There's now 36 states in D.C. with legal medical cannabis programs. The vast majority of workers live in those states and work in those states. 15 states in D.C. now have recreational cannabis, and there's more coming this year. I've already seen the legislation. The main thing to remember is that both President Biden and Vice President Harris campaigned on a platform of decriminalizing or legalizing cannabis. And once that happens, all of that case law under the Americans with Disabilities Act that has said, employers, you do not have to accommodate medical cannabis because it's an illegal drug. All of that case law goes away, and then it's going to be much more likely that you're going to have to consider accommodations. And the cases have been going that way anyway. A federal case in the U.S. District Court in Connecticut rejected the federal preemption argument, held that the Federal Controlled Substances Act does not regulate employment, and so it's not illegal to employ a medical marijuana user. And some of the state laws now, like in Arizona, have more robust employment protections in them. So Walmart, who won originally one of the big cases in the Court of Appeals under the Michigan law, because that law did not afford you any employment protections. It only protected you from criminal prosecution. They just lost a big case in Arizona, which does have employment protections. So take a look at your cases. Workers' comp is the other big area here. There was recently a case in New Jersey holding that an employer does not violate the Controlled Substances Act by reimbursing workers for medical cannabis for workers' comp purposes because they're not possessing it. And that there's a similar holding in New Hampshire. There's now some Pennsylvania cases that are going to be likely overturned because of these. And at this point, there's a bunch of states, a dozen of them, that have held that employers do have to reimburse workers for medical cannabis used for workers' comp purposes, usually in lieu of opiates. There are 4 states, Florida, Massachusetts, Michigan, and North Dakota, where you don't have to reimburse them. And right now there's some mixed rulings in Pennsylvania and Maryland, but there's a lot of states obviously that have not addressed this yet. So this is going to be the next frontier, I think, in HR law for you to be dealing with. So I know we went up to the top of the hour. Let's take a look and see if we do have any questions in chat. Moderator, do you have anything that you want to bring to my attention? Because I'm not seeing them in chat, and the question panel seems to have a few things, but it's hard for me to read it. It's not expanding.
Hi, Adele. Yes, you are correct. I am not seeing any questions at the moment. We did have someone in the beginning ask if this webinar is recorded, and just for everyone who is still attending, this will be recorded and it will be sent out to you after the webinar is over. But other than that, I think that's everything that we have right now.
Okay, well, then in closing, thank you for joining me here for the OSHA, EPLI, and the Biden administration, what safety and compliance changes to expect in 2021. As you can see, there are a lot of them. If you have questions that I was unable to answer, I'll be in contact with you and the moderator will provide those to me. And you can always email me as well. safetylawyer@gmail.com is on the slide. And I encourage you to follow Tandem HR on social media or on their blog or both for updated HR benefits and safety information. Thank you so much, and everybody stay well.